Hello everyone, welcome to channel. Today we will discuss on Section 8 company. If you want to start a company that serves a social cause while enjoying tax benefits, then stay tuned. In this video, we will break down everything about Section 8 companies under Companies Act 2013 and key features of Section 8 company and how to register and what are the compliances required and what are the benefits under Section 8 company. So now I will take you to MCA website. 1 second. I will share the screen. Yes. Now we will type MCA. Go to Google and type MCA, Ministry of Corporate Affairs. This is Ministry of Corporate Affairs. Here we have to click ads. Then under the ad, now we are going to Companies Act. This is Companies Act. Companies Act 2013. Now we have to go to Section 8. Section 8 company. So here prospect incorporation of companies. Here we can find formation of companies with charitable objects. This is Section 8. This is Section 8. Now I will explain in detail. Formation of companies with charitable objects. Notification dated 1st April 2014. So this section is notified on 1st April 2014. This is Companies Act 2013. So Section 8, where it is proposed, where it is proved to the satisfaction of the central government that a person or association of persons proposed to be registered under this act as a limited company. So what it says, even though it is for charitable objects, now we are registering as a limited company. So you might have seen society, trust, they are not limited. So here we are incorporating a limited company under Section 8 for charitable purpose. It is mentioned satisfaction of central government. Now we will see what is the central government. If you click here, in 2014, there is a notification. Here, central government means central government hereby delegate to the register of companies. So, ROC, here central government, generally central government means here under MCA, ROC, RD. So, this on 21st May 2024, it is notification. It clearly says central government hereby delegated power to register of companies. So here central government, so you are clear. Then it has in its objects, this company shall have in objects the promotion of commerce, art, science, sports, education, research, social welfare, religion, charity, protection of environment, or any such other objects. So these are the objects of Section 8 company and intends to apply its profits, if any, or other income in promoting its objects. What does it mean? During the charity, if company, Section 8 company gets any profits, so again it has to be used for the promoting its objects. So any profit arising out of the activities shall be used for the objects. Again, it has to be used for charity. So intends to prohibit the payment of dividend. See, if you see generally other companies, the members will get dividend on the profits. Here, it is prohibited under Section 8 company. There are no dividends to members. It is prohibited. Central government may by license issued in such manner as may be prescribed. Because Section 8 license will be given by the central government to the company. In earlier, we used to apply separate. Now, it is coming with incorporation itself. As may be prescribed. What it is as may be prescribed? Now, I will take you to the rules. So here if you see rules, rule 19, under section 8, license under section 8 for the new companies with charitable objects. So I'll explain you what it is. What is a license under section 8 company with charitable objects? A person or association of persons herein referred in this rule proposed a company desires of incorporating a company with limited liability under section 8. See, when they are proposed to incorporate a section 8 company, so you are getting with a limited liability without the addition to its name, word limited or private limited. Now, in this section 8 company, it is like, for example, XYZ Foundation. XYZ Private Limited, XYZ Limited will not be there. So, there is no need of adding the words limited, private limited. That will not be there in the section 8 company. At the end of the name of the company, it will be like association, foundation. So you can't find a limited or private limited. And this application for incorporation shall make in Spice Plus. In Spice Plus form, we have to apply along with the fee as provided in the company's registration offices and fees rules 2014. So we are applying through Spice Plus for incorporation of company section 8. And memorandum of association of the proposed company shall be in form INC 13. That is MOA for section 8 company. The application under subsection subrule 1 shall be accompanied by the following documents. While applying, the following documents are required, that is memorandum and articles of association of the proposed company and the declaration by an advocate or chartered accountant or cost accountant or company secretary in practice. They have to give a declaration that the memorandum and articles of association of the section 8 proposed company have been drawn up in conformity with the provisions of section 8 and rules made thereunder, and that all requirement of act and the rules made thereunder relating to registration of company under section 8 and matters incidental or supplemental thereto have been complied with. So any one of these professional has to certify that this proposed company has been complied with all the applicable laws and rules. An estimate of the future annual income and expenditure of the company for next 3 years, specifying the source of the income and objects of the expenditure. So this statement has to be attached along with the application. An estimation. This is a projection for next 3 years. Then the declaration by each person making that application, they have to give one declaration which has to be attached. If you see these 1, 2, 3, 4, you can find what are these. If you see, these are all amendments. 6 omitted, here it is mentioned. 7 omitted, it is mentioned. See, these are all amendments. One, the mention note is substituted by company's 6th amendment rules 2019. Second, again substituted. These are all amendments 1, 2, 3, 4. You can find in the section. I think you are clear about which is mentioned as may be prescribed. Again, we are going to section. See, we are talking, we are here. So the central government by license issued in such manner as may be prescribed. Now we have a clarity on the license under section 8. And on such conditions as it deems fit, allow that person or association of person to be registered as a limited company. Now, I just explained, even though this is a charity purpose, it is a limited company under this section without the addition to its name, the word limited or private limited, that will not be there. And thereupon, registrar shall, on application in the prescribed form, that is PICE 32, register such person or associates of person as a company, Section 8 company under this section. Hope you are clear up to this. Because at the name of the company, you can see XYZ Foundation or Ramana Foundation, like that. Foundation, association, but you won't find limited company or private company, private limited. So that is what is explained here. The company registered under this section, that is under section 8, shall enjoy all the privileges and be subject to all the obligations of limited companies. A firm may be a member of the company registered under this section. Not only individuals, even a firm also may be a member of the Section 8 company. A company registered under this section shall not alter the provisions of memorandum or articles except with the previous approval of the central government. So without ROC RD approval, we cannot change the memorandum and articles of the Section 8 company. A company registered under this section may convert itself into a company of any other kind only after complying with such conditions as may be prescribed. If this Section 8 company wishes to convert into normal company, private company, then it can be converted. There is a procedure. So a company registered under this section, I will explain how to convert this Section 8 company into private company because the procedure is given. This is as may be prescribed. If you click, then you can see what is the procedure for conversion of this company, this Section 8 company to private company. Then where it is proved to the satisfaction of the central government. Suppose if ROC RD is satisfied that a limited company registered under this act, that is, or under any previous company law, has been formed with an object specified in clause A. In clause A means that is charity objects. We have just discussed the objects and with the restrictions and prohibitions. What is a prohibition? Dividend is a prohibition. As mentioned above, it may by license allow the company to be registered under this section subject to conditions as central government deem fit and change its name by omitting the word limited or as the case may be the word private limited from its name, and thereupon registrar shall on application in the prescribed form. What here is explained is if any private company already registered now intends to do charity, then they can apply for conversion of private company into Section 8 company. That is what here it is mentioned. The central government may, that is ROC by order, revoke the license granted to a company registered under Section 8 if the company contravenes of the requirement of this section or any conditions subject to which license is issued or the affairs of the company are conducted fraudulently or in a manner violate the objects of the company or prejudicial to the public interest or without prejudice to any other action against the company under this act, direct the company to convert the status. Here what is explaining is if the company is involved in a fraudulent activities, this Section 8 company is not doing charity and involving in any fraudulent activity, then the ROC will direct the company to convert your status to Section 8 company to private company. That is a limited or the words private limited. But no such order shall be made unless the company is given a reasonable opportunity. So a company will get an opportunity to give explanation to the ROC and then only it will be converted. Opportunity will be given to the company. Provided that a copy of every such order shall be given to registrar. So once the order comes from central government, then that has to be filed with the registrar by the company. Where a license is revoked, when the license is cancelled, the central government may, by order, if it's satisfied that is essential in the public interest, direct the company be wound up. See, generally the company is doing activities in the market. So then ROC may feel that public interest. So okay, it is better it can be amalgamated with other company because assets will be there, no? So ROC, central government, if feels that, then it will direct for amalgamation with other company having a similar object, or direct to wound up the company. Central government has the power. So if no such order shall be made unless the company is given a reasonable opportunity of being heard. So opportunity will be given to the company to give explanation. Where a license is revoked under subsection 6, as we discussed, and where the central government satisfied that is essential in the public interest of the company registered under this section, should be amalgamated with another company. Just I explained, no? When this company is amalgamating with other company, then it will be amalgamated with other charitable company only, other section 8 company only. On the winding up or dissolution of the company registered under this section, there remains after satisfaction of C, if the company is wound up, then what will happen? First, you clear all the liabilities. Then still, if any assets are there, then it will not be distributed to the members. Subject to condition as tribunal. Here, tribunal means national company law tribunal may impose or may sold or proceed thereof credited to bankruptcy fund formed under section 224 of the Insolvency Bankruptcy Code 2016. So any assets are remained after satisfaction of the liabilities at the time of dissolution of the company. So the assets may be transferred to any other company registered under this section, or it will be transferred to insolvency and bankruptcy fund, which is formed under section 224. A company registered under this section shall amalgamate only with another company registered under this section having similar objects. So, if any company incorporated under section 8 wants to amalgamate, it has to be amalgamate with other company having registered under section 8 only. If the company makes any default in complying with any of the requirements laid down in this section, section 8 company, if contravenes any of the provisions, then the company shall, without prejudice to any other action under the provisions of this section, will be punishable. If any default is done, then the company will be punishable with a fine, which shall not be less than 10 lakh rupees, but which may extend to 1 crore. This is the fine to the company, and not only to the company and the directors and every officers of the company also punishable. Here, directors, I think you know, officer means who is officer. If you see, officer means it includes any director, manager, KMP, or any person in accordance with whose direction or instructions the board of directors or any one or more directors is or accustomed to act, whose directions the board of directors to accustomed to act. These are all called as officers, and they are all liable. If any default is done, all these people are liable. Who is in default shall be punishable with fine, which shall not less than 25,000 rupees, but which may extend to 25 lakh rupees. Earlier imprisonment was there. It is now, it is not there. Here you can see two. Two is amendment. In the down you can find this is omitted. Earlier it was there punishment. It is omitted with the amendment on 28th September 2020. Now you got it. So if any default in complying with the requirements, then company is punishable. Company and every officer, directors are also punishable, provided that when it is proved that affairs of the company were conducted fraudulently, then when fraud is involved, then every officer in default shall be liable for action under section 447. See, here it is a dangerous. If any fraud is involved by the company or any officers, then all are liable under section 447. If you see section 447, I'll take you to 447. The reason behind the intention is very good. Incorporation of Section 8 company for doing a charity. If any fraud is involved, it is a dangerous. If you see Section 447, see the punishment and imprisonment. Then I will show you that also. No, it is not coming. I think maybe technical issue. But I'll explain you Section 447 is a very dangerous. It is better not to come into that. If any fraud is done by Section 8 company or any directors or officers, they are liable for, they are punishable under imprisonment and penalty. So better not to do any fraud and we do charity, follow the rules and regulations, because the intention is good for doing a charity. This is what Section 8 under Companies Act 2013, formation of compliances with the charitable objects. This is notified on 1st April 2014. I hope you are very clear what is Section 8 of the Companies Act and what is Section 8 company and what is the formation and what are the objects, and if any deviation, what is the punishment. Thank you.